Hello, my name is Genaro Cortez. I'm a San Antonio criminal defense attorney, and today I'm going to do an explainer video showing you how a first-time DWI case works in San Antonio. This video is going to focus on a first-time misdemeanor case, and I'm going to answer three key questions. First, how do you bond a loved one out of jail after they're arrested for a DWI in Bexar County? Second, can you get an occupational license if DPS suspends your license after a DWI arrest? And third, what are your options in a DWI case for first-time offenders in San Antonio? So let's get started. First, this video is for information purposes only. It is not intended as legal advice. If you're arrested for a DWI, always speak to a Texas licensed attorney to give you specific advice on the facts of your case. The first thing that happens after police arrest you for DWI is they'll take you downtown to get booked and magged. They'll take your fingerprints, and then they'll also take you to see a judge. When you see the judge, that's going to be a big moment in your case. One of the things the judge is going to do is the judge is going to set a bond. Once you have a bond set, then your family members can hire a bond company and post your bond. There's often a lag between when police arrest you and when you see that judge to get magistrated. On busy weekends, it can take hours, if not days. The key point is, once you're magged, your family members can bond you out. If somebody you love is arrested for DWI, call the Bexar County Jail or the MAG's office and check to make sure they've been magistrated. Once they're magistrated and their bond is set, then just hire a bond company and post your bond. One of the first things you're going to want to do after a DWI arrest, after you bond out, is request an ALR hearing. Now, in Texas, after a police officer arrests you for DWI, the officer will physically take your driver's license and give you a piece of paper that has very fine print on it. The very fine print will tell you about something called the 15-day rule. In a nutshell, the 15-day rule goes like this. It says that you have 15 days from the day the officer takes your license to request an ALR hearing. If you don't request an ALR hearing, then DPS will suspend your driver's license after the 40th day from the date of your arrest. An ALR hearing is basically a hearing where you get to challenge the license suspension. In other words, if you don't agree that you are DWI, you can have that hearing and ask the administrative law judge not to suspend your license. In a majority of cases, the ALR judge will suspend your license, but it's a hearing worth having if you want to fight your case. There's a tactical reason for it that's a little more detailed and nuanced, but talk to your attorney about whether you want to move forward on that ALR hearing. Now, if the judge does suspend your license, you're likely eligible for an occupational license. An occupational license allows you to drive to work, to school, to daycare to drop off your kids, and to perform other essential needs while your driver's license is suspended for that DWI arrest. So what are your options in a DWI case? In a DWI case, there's two options, right? You can work something out if you don't want to fight the case, or you can plead not guilty and go to trial if you think you were sober or that the officer treated you unfairly. An experienced DWI attorney will walk you through that process. But here's how it begins. Set up an appointment to talk to your attorney to review the evidence. There's two key pieces of evidence you need to look at: the body and dash cam videos and the police reports. The police reports, they're not all the same, but they sound similar. It'll say that they pulled you over because you were weaving or you were speeding or you didn't put on your turn signal, some sort of traffic violation. The reports usually say, when I approached the window, the driver smelled like alcohol, bloodshot eyes, they were unsteady. So I asked them to get out of the car, and they performed the field sobriety tests. They failed the test, so I arrested them for DWI. Most reports read that way or a variation of that fact pattern. That's usually what you're going to hear. But what you're going to want to do with your attorney is sit down and look at the dash cam video and the body cam video. The dash cam video will show you how you were driving. Does it reflect what the police officer wrote in the police report? Same thing for the body cam video. The body cam video is going to show how you look. Were you unsteady on your feet? Were you slurring your words? And sometimes there's a big gap between what the police officer writes and what actually happens. There's no one size fits all. For some people, even when they have strong cases, they may not want to go to trial because they're afraid of risking jail time. For others, they're just like, absolutely not. I'm not going to plead guilty to something I didn't do. I want a trial. In either scenario, that decision is solely up to the client. A lawyer cannot twist your arm one way or the other. So once you make a decision, your decision is final. But if you change your mind, let your lawyer know so they can adjust their trial strategy. Now, if you decide to take probation, here's how that works. While you're on probation, you have to report to a probation officer, pay fines, pay court costs, perform community service hours, complete a driver education course. In some cases, you may also have to do a driver impact panel course. A driver impact panel course is either video or live. And then what happens is you have to watch family members of people that were hurt explain how DWI affected their lives. You're going to have to submit your regular drug and alcohol test. In some cases, the judge may also order that you have an ignition interlock device installed on your car. Now, I want to talk to you about different types of probation for DWI. There's deferred adjudication probation and straight probation. Deferred adjudication probation is just like the probation we talked about, except the judge doesn't find you guilty. You usually see these in plea deals, plea bargains. In fact, in a lot of DWI cases, you don't plead guilty to DWI. You can plead guilty to an obstruction charge. And in some cases, you can probably work something out with a prosecutor to avoid a conviction altogether. But those are more rare, and you need to talk to your attorney about that. With a conviction, the judge finds you guilty of the DWI or a jury, and instead of sending you to jail, you go on probation and complete the same programs. So the main takeaway on these cases is that deferred, there's no finding of guilt. With regular probation, there is a finding of guilt. If you're a veteran, or if you served in the military, you may be eligible for a veterans court. If you complete that program, you may be able to get that DWI case off your record. If this video is helpful, please click the like button below and subscribe to our channel. So what are aggravating factors in a DWI case? There's three major factors that can make a simple DWI more serious. The first one is if you drive with a child in your car. If that's the case, then a simple DWI that's a Class B misdemeanor and has at most 6 months in jail turns into a state jail felony that carries a minimum of 6 months up to 2 years in a state jail facility. The second factor is if you have a really high blood alcohol content. So when you get tested for, when you give a breath or blood sample and your BAC is at 0.15 or higher, that is considered aggravating, and it'll turn your misdemeanor Class B into a Class A misdemeanor. Third, if you DWI and you crash and there's an accident, somebody's hurt or killed, that'll make it into either an intoxication assault or intoxication manslaughter. An intoxication assault is a third-degree felony, and it carries between 2 and 10 years in prison. Intoxication manslaughter carries between 2 and 20 years in prison. There's one more thing that comes up in these DWI cases in San Antonio, specifically San Antonio. If you're not a U.S. citizen, for example, if you're a legal permanent resident, you have political asylum, or you have no status at all, then you're going to want to talk to an immigration attorney if police arrest you for DWI. That's because there's a Supreme Court case called Padilla versus Kentucky, and it requires defense counsel to tell clients the immigration consequences of pleading guilty or no contest to a crime. Even a simple DWI can affect your ability to stay in the country, to become a U.S. citizen, and it may result in you being deported or excluded. Always, always, always talk to an immigration attorney if you're not a U.S. citizen and you're arrested for any crime, including DWI. And that's how DWI cases work in San Antonio for first-time offenders. If you have a case, don't panic. You have options. What I recommend is you speak to a qualified DWI attorney to walk you through the steps and to give you specific advice on how the facts and law apply to your case. Hopefully this video is helpful. Again, if it is, please click the like button below and subscribe to our channel.